Yeah, so we can do the whole in English. Yeah. Can you come closer? There is already a gap here. And so I'm Jean-Guy Lecat. I was involved with this question of the copyright now for 3 years. The United Nations, who have an organization who take care about the copyright based in Geneva, asked me to contact people all around the world. And for 1 year and a half, I contact about 250 people. We send them a questionnaire to know in which situation the copyright are in their country for all the creative person who work in live art, who are mostly scenographer, directors, costume design, light design, could be also props in theater, in opera, in a circus, street theater, dance. All of the artists, creative artists working in that different art are normally protected from a long time, and most of them don't know anything about that. And the questionnaire was important because the law, the transcription of what was decided a long time ago about the protection of the artists were translated in a different country in a different way. For instance, in France, I'm not artist, I'm a technician. So that questionnaire was very interesting to see how different are, the protection are the same, but the translation in the law was completely different. So we have very important person here from Thailand, from Romania, from Georgia, and the representative of WIPO, Christina Langer. So it will be interesting you present yourself to have a different point of view. For instance, have met a friend from Morocco, is not here, but there is a country where the law are very developed, and Georgia is one, and a country like France where the law is not. The country of the theater. that's interesting. So, and this is because in most of the country, it's not because the government don't want to do it. It's because all the law have to go through parliament. For instance, to be Christine here, she's technician like me. We are not artists. And she's design a light. So the law have to come from the parliament. And you can imagine the parliament has a lot of things to do except to think about the artists. So I think we can wait for a long time. But it will happen one day, probably. So that questionnaire, we receive about 100, something like that, 65. Yeah, from 7 countries different, so which is not too bad. And you say it's not too bad.
It's not too bad, but what I was saying is that we had about 70 answers or responses to this questionnaire from roughly 40 countries. This is a good start, but we had to be a bit careful because we sent it out to the whole sector. So we got answers from stage directors, from set designers, from costume designers. And of course, the situation for each of these professionals can be different. And then also from one country to another, the situation can be different. However, we had some kind of global trends that we could kind of pull out from the responses that we received.
And then we organized a meeting, a round table in Geneva for 2 days with about 20 different countries to explore the main question. And then we make a list of very important questions. How can we not just tell artists they are protected, but how they can be protected? Because in the music, the composer, the writer, have a big organization everywhere who take care about if their work is copied somewhere. That absolutely not exist in live art. I just come from Mexico visiting an exhibition and see a set I did in Madrid 5 years ago. Exactly the same. What can I do? It's in Mexico. If there is not a big organization watching around, the copy will be with all the instruments we have. I see a play in Mexico in the National Theater, 20 people were filming the whole show. So it's a very important question. From that meeting we had in Geneva, we are several of us to organize a meeting in the festival, because the festival is a good place to spread information and to share different point of view. This is one. We were with Adrian in Targovic, and they do the same in Singapore. They are doing the same in Spain, in a different country. So this is the second step to try to organize that, and we will see next year how we can go further. And so Christina is going to explain a little more about WIPO.
Yeah, happy to do so. Well, WIPO is the World Intellectual Property Organization. We're a UN organization like UNESCO, the World Health Organization, etc. And as one of these specialized agencies, our priority is intellectual property. So we have a sector on patents, on trademarks, industrial designs. And we also have one big sector on copyright and the creative industries. And this is where I work. And we do a lot of different things, from broadcasting to gaming to IP and sports, and basically covering the whole creative industries. But one topic we're also discussing since a couple of years now is copyright for theater and what protection does exist or not. We started a couple of years ago with a scoping study, which was basically a mapping of the situation worldwide. Back then, we only focused on the stage directors to get an idea of what is the legal protection that we see worldwide. Is there protection? And if so, how is it provided? In some countries, it's an author's right, so they're considered an author, someone who creates an own work, having protection under that kind of author right. In some other countries, they're considered performers. The argument is to say, well, the work is already there, they're just bringing it on stage. So it's a sort of performing the work, so they're protected under performance rights. So this example of the stage director showed us that already for this one group, the way of protection is different, the approaches are different, and in some countries there's even nothing. So there's no legal basis for the protection of stage directors. Following that study, we decided to enlarge the scope a bit more, not only looking at the stage directors, but we thought if the stage directors have these kind of challenges and have not really a clear legal framework, maybe this also applies for other creators in the live arts. And as Jean-Guy already said, there are some groups like the writers, the composers. For them, the legal situation is pretty clear. The same for everyone who's on stage, who's performing, like musicians, actors, dancers. For them as well, there's a pretty well-established legal framework. But then there are many, many others who work usually backstage, providing more or less creative input to a production, and the legal situation for all these creators is not really clear. And it depends on the country where you are. The situation can really vary from one region to another. And so with that, we kind of opened up the frame of our work, now looking at all these behind-the-scenes professionals, set designers, conductors, choreographers, you name them, the list is long. And our work really focuses, and Jean-Guy has already outlined, we started with a questionnaire to get an overall kind of, well, first impression of what are the main and burning issues. And then we had this more of a deep dive conversation in the brainstorming session that we had in March. And Natta, for example, was there. Adrian was there. So it was 2 intense days. Sorry again. But for us, it was very helpful to get this really on-the-ground feedback and to know what are the problems, actually. So it was very interesting for us. And now we're really kind of at the point to think, okay, now that we kind of started this analysis, what do we do with that now? What are the possible reactions or actions that could be taken in order to address some of these, well, challenges that we have seen? And we will probably hear on some of that from our speakers today. And then, of course, the idea also is to have a bit of a brainstorming and a discussion, ideally with all of you, to kind of come up with possible, well, what could be done and how to address these challenges and questions that we see.
Yeah, it's a very large question. So I have in memory 2 examples. One is about a famous problem one director have. One show was created in Zurich, I think, in Switzerland. And a friend of the director who was in Paris see a poster who almost looks the same, and he thought that was the show he saw in Zurich who were traveling to Paris. And then he go to see the show, and then he realized it was an exact copy made by a French director. The same direction and the same set, more or less same light. So the director from Switzerland go to the court, he win. But what is interesting behind that? The judge asked him, can you prove you are the director? And then the director came with a book with all the notes he take on the book. And the judge said, this doesn't prove anything. We win because the judge finally, but it's interesting, it's important because many directors don't care about that, and they have, and if nobody films them, for instance, working with the actors or something like that, he cannot prove he was. There is another example, me, because now there is 2 problems. The problem is the money the theater have, and the big theater have a storage place where they store the costume and the set. And to save money, they ask the designer, can you visit a storage place? Maybe there is something you can reuse. And at the same time, there is many organizations like the French Union of Scenographers who push artists to recycle their work for the ecological question. The question is, if I choose part of the set of some costume, did they call the artist who did it? No. So you arrive watching an opera and you see part of your work on stage and you did know. And that's very often. And most of the scenographer or costume designer I asked them the last 2 years, they had that question. And where it's not just a question of money, it's also, if they reuse part of my set, maybe they can ask me to check. Or And also, when you sign a contract, you give your right, and then they give you money, and you give your right. Otherwise, they cannot use your set or your costume. But your right for how many times? I did an opera in Liège Opera. Last year, they redo it. So I called and they said, but you give the right. No, but they give my right for the creation. No. So I did. I don't check on the contract the date. So that's something we were talking about in WIPO to maybe create some form of contract who can be universal, because many artists sign a contract against their right. So maybe you can present yourself first.
All right. I'm Natta from Thailand. I am a curator with background in theater design. After I graduate from Hong Kong, I work in the gallery and then explore the scenographic idea in arts experience as well. So, yes, this is my background.
Hello, I'm Iulia Popovici. I'm from Bucharest. I haven't curated something in theater for some time, but I'm a theater critic, and let's say I'm an expert in problems of the culture field, both in legal and economic terms.
Hello, my name is Ionuț Colan. I'm the bad guy here. I'm the legal one. I'm a member of Bar of Bucharest. I have already, I think, 30 years of experience in IP, intellectual property, especially in the cinema industry and advertising industry. And advertising is still one of the most important investor in live arts. And in theater too, not especially, but in theater too.
Hello, my name is Gvanța Turmanidze. I'm a member of Oyster Center in Georgia, and I'm working with Nino Gunia at the moment, helping her with the translation about copyright.
Hello, my name Nino Gunia-Kuznetsova. I was a scenographer and now working as a curator and teacher. Thank you.
So we can start first by to know in a different country what are the legalization, how different government organize the protection of the artist.
All right. In Thailand, the performing art, particularly in live performing art, we face the significant legal problems. When it's come to intellectual properties, right, the artists, we always aware of that as an artist, we aware there's an IP, right, in terms of using the laws and stuff. But back into Thailand, where performing arts sector is quite small, so we didn't get any grant from the government. And also what we do in terms of collaborating between artists and theater groups is collaboration with a journalist. So we don't even sign the contract on working to each other. So it's negotiation about the contract, because the problem is we don't have any standard on the working. Even we don't have union. We don't have the standardized of the wage regulation, and also that lead to the problem that artists and performing art artists, including scenographer and people who work in theater, they don't even care how to apply to it, and then why they have to apply to it, because what they do is not recognized by the government. this is the situation like at this moment. Yes.
Before I give it to the legal guy here, I have to say something briefly. First, the protection of copyrights of intellectual property in terms of arts in Romania comes from the EU, because our law is a transposition of the European directive. One of the problems is that the transpositions usually mean the direct translation of the directive, and somehow it gives a lot of uncertainties and things that are very difficult to actually apply to make life of artists easier. Our system first gives a lot of power, extraordinary power, to the so-called collective management organisms, which are in charge of certain rights for performing artists. And basically, the whole system is somehow set to give these organisms an overreaching power. The organism in charge of the state institution in charge of authors' rights is called the Romanian Office for Authors' Rights, and it has very little, in my experience, activity other than organized negotiations for the collective agreements related to these collective management organisms. Otherwise, we do recognize set designers as authors. We do recognize choreographers as authors. Stage directors are performing artists. And we are a very creative nation, because copyright contract, income coming from copyrights is very generously untaxed. We have a flat rate of 40% for copyright income. In a situation where, for instance, the taxation for work is very high, is at 43%, which means that the copyright contracts are are very used, including in situations. Well, I'm nice. We have a very famous situation where pretty much 90% of the personnel of the staff of a television was contracted through this kind of copyright contracts, including camera people, a situation which is and drivers and so on. But pretty much everybody, including the secretary, was on copyright. And usually we do have a lot of copyright contracts because they are because they are used to fiscally optimize people. This is a very nice way to say they are abused for tax purposes. It's interesting because in certain situations it leads to nice discussions about why camera people cannot have copyrights. Because after the huge scandal about the people in the television staff, there was an intention to protect their so-called rights. And the discussion was, but in this case, all televisions will become bankrupt, and everybody who films something is protected by default, which is something that goes a little beyond the scope of IP protection. But this leads to the situation where copyright contracts are very common. People are very delighted because they are so fiscally efficient. they are not very interested in the protection that comes with such a contract. Actually, my impression is that the social contract between the state and the cultural people that sign this kind of contracts is sort of a don't ask, don't tell. We are not taxing you very much. You don't ask much from us, which generates a little chaos. But we are a very creative nation. I think everybody in this room had a copyright contract at some point, including him.
I'm an author, of course. I'll be a little more technical. We have a law called Law Number 8 of 1996 of authors' rights and related rights, or neighbor rights, as you wish to say. This law was republished, and subsequently a lot added and modified. At the beginning in 1996 was more or less copied after Code de la propriété intellectuelle from France. We have a long tradition in copying French legislation. And at the beginning was a quite good law, I mean, a very logical law. Unfortunately, during the last 3 or 4 years, the law was amended using a lot of economical terms, words, which are not very customized to the legal language.
Because of transposition.
Yeah. And now, for example, the law says the only way to transfer a author right, actually, is contract of assignment, cession. But 2 articles after that, the new article, the law said the license go to what is license. If the only way to transfer the right is the assignment. So this is the situation. Actually, we have now a kind of inconsistency of the terms in law. Regarding the rights of the stage directors, of the metteurs en scène, Mrs. Popovici has right. An article said, well, the artists are the people playing, executing, directing. So we can go with our mind to the idea that a stage director is a performing artist. In the same time, in the first part of the law, looking to the work and to the copyright, the law said is looking to original work as, I don't know, novels, poetry, etc., dramatic work, dramatic or musical work, and some letters after that to any derivate work. And derivate work is any adaptation or other kind of transformation of a pre-existing work. So if you are looking to the fact that especially a film, an audiovisual work, is an adaptation of a script, why not a theater show, a theater performance is not an adaptation of a play, of Chekhov or Shakespeare play. So it's quite schizophrenic. The stage directors are explicitly performing artists, but in the same time, the adaptation of the play, of the theater play, could be a work. But the creator of a work is an author, is not a performing artist. So we are in between the waters, let's say, and in this respect. This is bad and this is good in the same time. In practice, I've seen between stage directors and theaters contracts for assigning author's right, I've seen contracts assigning related right, and I've seen contracts assigning intellectual property, all kind of intellectual property, because nobody was sure what it is. I say, okay, we put a big term, intellectual property. So this is in big view, in big line. Of course, some of the rights of other kind of creators, like designers, for example. Thanks to God, Romanian legislation allow the double protection, for example. I mean, for example, this chair, if it is a work, it is original, could be a work in a sense, in respect of copyright, let's say copyright. And in the same time, could be protected as design, industrial design. Romanian legislation permit that. Other countries, including in EU, doesn't. I think Italy, no. France, yes. Germany, I think no. I don't know, Switzerland. I think, but it's just it's just an idea. For sure, let's say a designer of a beautiful, I don't know, dress could be the author of that particular dress, but not in the same time an author of the show where the dress is used. I'm not sure even. I'm thinking now in parallel with the situation of movies and other audiovisual works, where in contract between the producer and the main author, which is the director, this contract could establish the right to be considered author of the AV work to other creators. In case of theater, we have not a text allowing this play, this little play, in my view. But in the same time, I don't know any case in law where a judge said, no, it's not possible. Nobody tried until now, at least at my knowledge.
Monopolize the discussion with Romanian case, but as Ionut said, in 1996, when we adopted this law, firstly, it was revolutionary, because before that, Romania didn't recognize related rights. The law was same with a lot of countries. So it's no socialist country or member of states, members of the Soviet Union, signed the Rome Convention or had related rights. Which means that for actors in general, especially for actors in film, it was rather complicated. It was revolutionary for the theater, and the theater union in Romania was the main supporter of this of the first version of the law, because they saw it as a recognition of their condition, of the actors and other performers in theater as artists. And the importance of this law was always centered on how it recognized recognized the condition of artists for those that were covered by it. And somehow in time, the whole fiscal thing and the very weird social contract that we have with the state in this situation made it very diluted. If everybody can be covered by copyright and everything is either a performance or a performing activity or a work of art, nothing is.
According from your examples, like talking about the costume designer, like so the ideas like design can't be protected as we can't have the right in our design, but we can have the right in the expression. So from your examples, like the costume designer can have their own protections of the costume design. Is it?
Yes,
Oh.
If this costume, this dress, this how do you just, it's original. What is meaning original? Well, is very tricky to say. The law doesn't define the originality. At the end, only a judge could say this is original or not. You know, the judge knows everything. That's it. But if a work is original, this work could be protected, is protected by law, by simple creation.
And actually, the costume designer signs in their contracts that the work is original. And then if they go to trial, that there would be a judge saying that it is or it is not original. But actually, it covers everything.
Generally, a case in this area is about 5 to 6 years to have a final solution. So, well.
So we don't have trials on that.
It's very quick.
Yeah, but maybe after we will come back to the origin of the idea of protection, because it's not clear. For instance, in France, we have a huge debate between scenographer and the directors. The directors said, I gave the idea of the set, but the idea are not protected. So even if the idea of the set comes from the director, the set designer have a protection. Same with the costume, for instance, we use a costume of today. Where is the protection? We buy a costume in the shop, you know. So that's why it's interesting to come back to the origin of the idea of the protection. What do we protect?
No, the idea are not protected under our law, and generally under any European country's law.
Idea is not protected.
It's expressly reviewed by the law. The ideas are not protected. So only the original expression of an idea is protected. I know, for example, in all law books, we say that the idea of a man loving a woman and the Romeo and Juliet idea, well, it's universal. This idea is not protected. It is protected, it was protected, let's say, the story of Romeo and Juliet, written by William Shakespeare or by X or by Y, in Greek. But the idea is not protected.
No, exactly. You have the idea to buy a T-shirt. You are a scenographer. Oh, sorry. You have the scenographer. You have the idea to buy a T-shirt. But there is no creation.
Okay, let me say it one more time. It's Romania gives the right to a copyright contract to any set designer or costume designer. What it is really protected, we don't know, because in the end it goes to if that right is menaced by somebody. We use it mainly for fiscal reasons. We don't know what it is protected.
We have these contracts, but we don't know what the exactly work is. Yeah.
We don't know what the work
Well,
is.
at the beginning, we have a big confusion between authors and artists. In common language, well, every writer is an artist. Well, in Legalize, is not. Yeah. A writer is an author, a musician, a composer is an author. The singer is an artist.
That's not the same musician and actors. They have a right, but not the same like.
The author.
Christina will come back because she knows very well that question. But it's not, yeah, it's very important to make a difference because all the artists are not on the same level. We are speaking about the author. But a clown, it's on stage and is author of his character. But he's not protected like the scenographer. He's protected with a copyright on the side, like most of the actors.
მოგესალმებით, მადლობა მოწვევისთვის.
Hello, thank you for inviting us.
მე უბრალოდ მინდა მოკლედ თქვა, რისგან შედგება საქართველოში სისტემა. ნუ პირველი ეს არის კანონმდებლობა.
I want to, first of all, talk about the system in Georgia, and it consists of, first of all, the legislation.
ინსტიტუციური მოწყობა, ანუ რომელი ინსტიტუციები განაგებენ ამას,
Which institutions are kind of implementing the work.
შემდეგ ახსრულების პრობლემა და მათ შორის სასამართლო და ბოლოს ცნობიერების საკითხი და კულტურის პოლიტიკა.
Then the implementation and
სასამართლოს სისტემა, რომელიც აღასრულებს დაცვას.
And then the legislation, the law which is governed by the court.
კულტურის პოლიტიკა და ცნობიერების დონე.
Cultural policy and awareness raising.
რაც ეხება კანონმდებლობას, 99-ში იყო მიღებული კანონი, საკმაოდ კარგი და შემდეგ განიცადა გარკვეული მოდიფიცირება და შარშან 23 წელს კონსოლიდირებული ვერსია შეიქმნა.
The law on copyright and related rights was adopted in 1999 and was modified in 2023.
ამ კანონში საკმაოდ კარგად არის ბევრი რამ გაწერილი, თუმცა აი რაზეც ჩვენთან ახლა ლაპარაკი იყო თეატრის რეჟისორები ცალკე ნახსენები არ არის.
The law is actually very well written, and it's very functional. But what we were talking about now, the stage directors are not mentioned there.
მაგრამ არიან დაუშვათ კინორეჟისორები, როგორც ავტორები მოხსენიებული.
But cinema, film directors are mentioned there.
და შემსრულებლები არიან დაუშვათ იგივე მსახიობები, მუსიკოსები და ასე შემდეგ. რომელსაც საავტორო უფლება არ გააჩნიათ. შემსრულებლის უფლება აქვთ.
And performance, like actors and musicians, have a copyright of performance, not as artists.
მაგრამ ჩვენთან რეჟისორებს ძალიან დიდი ძალა აქვთ საქართველოში, ამიტომ ისინი მიუხედავად იმისა, რომ კანონში ეს გაწერილი არ არის, თავის ავტორო უფლებებზე იბრძვიან და ეს ტარიფებშიც არის ასახული.
Directors in Georgia, theater directors, are themselves quite powerful. So they fight for their rights, and they are respected professionals. So things, kind of are managed in that respect way, to say so.
ესე იგი, საქართველოში არსებობს საავტორო უფლებების დაცვის ზემდგომი ორგანიზაცია საკპატენტი, ანუ ეს დამოუკიდებელი ინსტიტუცია, რომელიც ამ დარგში პოლიტიკას განაგებს.
We have this independent organization in Georgia, sakpatenti it's called, which is actually responsible for the implementation of legislation and policy in copyright field.
საბჭოთა კავშირის დროინდელი ორგანიზაცია, რომელიც ავტორო უფლებების მართვის იყო არსებობდა მუდამ ჩვენთან, ანუ ეს არ გაწყვეტილა ეს ტრადიცია.
Coming from the Soviet times, there was always this organization which was implementing copyright and protecting copyright in Georgia. So the tradition goes on starting from those times.
მაგრამ გარკვეულწილად პოლიტიკური სიტუაციის მიხედვით იცვლებოდა მენეჯმენტი ამ ორგანიზაციის.
But unfortunately, the management was changing according to the political situation in the country.
23 წელს რომ ის ცვლილებები, რომელიც განხორციელდა კანონში, თავისთავად ძალიან პოზიტიურია, როგორც კანონის თვალსაზრისით.
The amendments that were made to the law in 2023 are quite good and well done.
და ის ეხება სწორედ ასეთი ორგანიზაციის აკრედიტაციის საკითხებს და პირობებს.
And it refers to the accreditation of such organizations.
და მაგრამ ამავე დროს ამ ცვლილებამ ხელი შეუწყო ძველი ორგანიზაციის აკრედიტაციის წართმევას და ახლა გვაქვს ახალი ორგანიზაცია, რომელსაც აკრედიტაცია მიენიჭა.
So what happened after these amendments with the accreditation system is that old organization which existed and had a long professional history couldn't undergo this accreditation. And there was another new organization created which actually has undergone this accreditation.
ანუ კანონის თვალსაზრისით სიტუაცია კარგია. პრობლემა არის აღსრულება და პრობლემა არის ცნობიერების ამაღლება საზოგადოებაში და პროფესიონალებში.
Yes. We think that the law has no problem. But we have a problem with implementation and with awareness raising.
Yes.
And awareness raising is
ჩვენ ქონდა აქ წამოსვლის წინ კონსულტაციები როგორც ადვოკატებთან, რომლებიც იცავენ საავტორო უფლებებს სასამართლოში, ასევე ამ ახალი საავტორო უფლებების დამცველი ორგანიზაციის წევრებთან.
We actually had consultations before coming here with advocates who are precisely dealing with property rights, with authors' rights, and we also had consultation with this new organization which has undergone the accreditation.
და თვითონ кейსები ცოტაა სასამართლოში შედარებით. პრაქტიკა სასამართლო მწირია.
Court practice is very low at the moment.
და მაგრამ როდესაც ხდება დამტკიცება საავტორო უფლებების დარღვევის, რა თქმა უნდა, სასამართლო ყოველთვის ამ უფლებებს იცავს. ანუ სასამართლოში პრობლემა ამ მხრივ არ არის.
If there are infringements, then the court is involved and there is no problem with that.
მაგრამ არის პრობლემა საზოგადოებრივი ცნობიერების, მათ შორის პროფესიონალების, რომლებიც არ აკითხავენ სასამართლოს და მოსამართლეებში და ექსპერტებში დაბალი ცნობიერება საკითხზე.
But there is a big problem still, particularly with professionals who don't apply to the court and with judges also who don't know the field very well.
ზოგადად პოლიტიკაში, რომელიც კარგ კანონმდებლობას სათავისოდ იყენებს.
And generally there is a problem in the policy which is used for their which is used by the government in the direction of their well-being.
ხვალ უთხარი რომ არის ჩვენთან საპარლამენტო არჩევნები და რომ დაუბრუნდებით, იმედია რომ საბჭოთა კავშირში აღარ აღმოვჩნდებით.
Tomorrow we have parliamentary elections in Georgia and we hope we will not return to Soviet times.
Good. So it's not so simple Because there is a copyright and there is a relative copyright. For instance, actors could have
Related rights or neighbor rights.
yeah. But to come back to the idea of the clown with a specific mask and costume, he is an artist with a relative right, but is also a creative person. Yeah. And there is two systems in a word. There is the main system where any author, any creative artist is protected at the moment he starts working. If he can prove from sketch or anything, he have created something. If you go to buy a T-shirt as a costume design, there is no protection. No, if you have to be filmed in a shop, you buy the T-shirt. Yeah. So it's a real question, for instance, about the directors to prove in a court they are the director of the show. How to prove it? And there is a second system, which is a Anglo-Saxon system, where the right belongs to the producer to do that sample. It's not that simple, but so the artists in the main system around the world are protected. For instance, Shakespeare is still protected; it's forever. So if there is a family of Shakespeare, they can say not the money, but
Well, not necessarily. I mean, what is protected is maybe still the moral rights in some
the
jurisdictions.
moral rights are
but
forever.
The
Yeah.
moral rights are forever. The economic rights, so all those
For
rights that
70
allow
years.
you
Yeah.
to
No, it
monetize.
depends of the country. It's 70 years in France.
70 years after the death of the creator.
Yeah. So, Christina is going to come back a little history about copyright, just to make that system simple. Between the moral and the money question.
Well, basically, if you have copyright protection, there are two sides to that. One side is the moral right, which is, for example, the right that you are identified and recognized as the author of your play or as the author of your book. So it's really closely linked from the creator to the work. And in most jurisdictions, these kind of rights can also not be transferred to a third party, but they stick with the creator. This is also the right, which sometimes is a question of, we had this in the US, for example, in some past elections, where some bands were played in the election campaigns, and then they said, oh, wait, but you're playing our music. Actually, we don't have nothing to do with this one candidate or the other candidate. Please don't play our music, because it gives us the impression that we are somewhat linked to that. So even you have the right to say, I don't want my work to be used in a way that could be negative for myself. So there's also an element of protecting the reputation of the original creator. So these are the moral rights which are really closely linked to the creator, him or herself. And then, in addition to these moral rights, you have economic rights. And these are really those rights that you can use in order to monetize your work. So here it's very much about who can use my work? Can my work be copied? If I, for example, write a book, will there be a translation? Which markets do I want to go for? Can my book only be printed, or can I also put it online? So all these questions of what do I do with my work, this is all coming under the economic rights, and these are the rights that allow creators to actually monetize their work and make a living based on their copyrights. So these are the two, we have the lawyer in the room, but these are the two kind of sides of the copyright. And while the moral rights usually stay with the creator, these economic rights can actually pass on to another person, or they can even be inherited to the children. So if you take the example of the book, you can give some of these economic rights to your publisher so that they can do the marketing for you, that they can publish the work for you, get the translations done, etc. And these economic rights, they actually lapse. So we have an international convention for copyright, and there it is said that the minimum protection should be 50 years after the death of the creator. And at the moment, we have a lot of jurisdictions that even are more generous. So like France or also Germany, I don't know how it is in Romania, probably also 70 years. Same in Georgia, Thailand, 70? Okay, so this, you see, it's an even more generous protection going beyond the minimum of 50 years. But eventually these rights lapse, and then you have your work in the public domain, which is, for example, the case with Shakespeare. So everyone can go and take the Shakespeare play and make a movie out of it, translate it, publish it in a new edition, bring it on the market as a book. So no one can stop you from that because these economic rights have lapsed. But what stays can be the moral rights, not in all jurisdictions, but in most jurisdictions, these moral rights are perpetual. So they continue even after the death of the author and even after the economic rights have lapsed.
It's clear? No, it's important because when we are talking about a creative art in general, it's easy to say, this is my painting, my sculpture, my text, etc. In live theater, for instance, Christine is here. What's the difference between the light to light the actor and the artistic light? At what moment the light, we have a big discussion with the light design in France. At one moment, the light design is a creative person. So that's the first point. The second one, and will be interesting to speak about that, it's how can we have a better protection?
Well, I'm thinking now to the situation of DOPs, director of photography. In some parts of the world, they are recognized as authors, having copyright, let's say, on the movie, on the audiovisual work. In other parts of the world, including Romania, they have not this right. They are, ab initio, viewed as technicians. They could be recognized as authors of the movie if the director, the main author, and the producer recognized this quality in the contract of production of the movie.
But they become, this way, they become authors of the movie.
Yeah.
They don't receive author's rights in their own name.
They become co-authors of the movie.
Because by our law, the director, the scriptwriter, and the composer of original music are recognized by default as authors, and as Ionut said, everybody else, if they want, can be an author. And this is a huge issue. I can tell you that there is a discussion and initiative in the parliament for DOPs, and this is in the making, and I hope that it will go with the recognition of authors' rights in the case of stage directors.
It's already 20 years history of this proposal.
No. It's a new one. The previous one was mixing.
Each 5 years they come again.
No. This is for real. But the last one was mixing DOPs with camera people, which was very, very, very complicated.
Yeah. But in all the time, the law allows that a person who believes himself, herself, as a wish, to be a creator of something, to go to the judge and asking to be recognized as an author. For sure, it will be very difficult to convince the judge you are the author. but allows, in theory, allows that. So, if you think that you are the author of something, of an work, of an original work, you can go to the court and trying to have recognized your quality of an author of an work. Even if in the law your category of creation is not expressly recognized as an work. I don't know if I am really well understood.
In the beginnings of the work, we can make the contact by negotiations, like who's going to be the authors, and like director can co-author with the designer, with the cameraman.
Well, that depends on the work. I repeat, in audiovisual work, it is possible. Right. In other categories of work, as in theater, it's disputable.
Wow.
სასამართლო პრაქტიკაზე მინდა ვთქვა ორი სიტყვა.
I want to say 2 words about court practice.
როგორც ვთქვი, ესე იგი სასამართლოში მიმართვიანობა ცოტა, მაგრამ ძირითადად ამას მიმართავენ ახალგაზრდა ხელოვანები, მათ შორის რეჟისორები.
Well, cases in court are very low, as I said previously, but if it happens, it's mainly young directors.
აი ახლა ჩვენ ვიცით, რომ რამდენიმე საქმე არის წარმოებაში, ერთი სცენოგრაფის, რომელიც უჩივის არამატერიალურ ავტორო უფლებების დარღვევაში თიაც და აგრეთვე ერთ-ერთი რეჟისორი, რომელიც პოლიტიკურ პარტიას უჩივის მისი სპექტაკლის, ასე ვთქვათ, პოლიტიკური გამოყენებისათვის.
We have 2 cases at the moment going on in court. One is about using scenography, and then another one is and another one is director, theater director, young theater director, who is who has this case in the court about using his play by political party in a clip. They used it in a clip.
და რამდენადაც მე ვიცი, ნუ სცენოგრაფის საქმე ჯერ დაწყებულია, მაგრამ ასეთ შემთხვევაში დისკრეცია აქვს მოსამართლეს. ანუ კანონში ზუსტად ეს არ არის გაწერილი და კანონის ნაკლი ალბათ ეს არის. და იმის მიხედვით თუ რამდენად, ასე ვთქვათ, ჩახედულია მოსამართლე, იმის მიხედვით შეიძლება გადაწყდეს ესა თუ ის საქმე.
So discreditation in this situation is up to the judge, and the case will be probably the outcome, result of the case will be probably dependent on the judge. How well does he know the situation or the field itself? This is the situation with the scenography usage.
და პრობლემა არის, რომ თუ მოსამართლე ვერ ერკვევა საქმეში, მაშინ უნდა მოიწვიოს დამოუკიდებელი ექსპერტი და ამ ექსპერტების პრობლემაც არის.
And there is a big problem with inviting experts to be involved in case when the judge doesn't know the field very well.
Well, it's quite similar to our case in civil cases, and not only in civil, but in civil cases. The judge needs the opinion of a technical experts. Some of them are organized by the Ministry of Justice in the corps of technical experts. But if a specific matter, they are not technical experts, you have the possibility to request the activity of a well-known person in that matter. of a famous, let's say, professional in that matter as expert.
Okay, in Romania, most cases never end up in court. In most of situations, when artists are not actually protected, they don't end up with a lawyer. I know a case of, there's a famous set designer there that wants to say something, but I have 3 examples first. There's a well-known known stage director who's also playwright, who saw half of her recently premiered play published in a local newspaper in a town in Romania without her consent. Well, she decided not to do anything in this situation because she was also the manager of the theater, and the newspaper was in an active conflict with herself and the theater. So she somehow relinquished her moral rights and somehow decided not to take this great precedent to court to make it important for the whole field, because it would have complicated the local situation in a very small provincial town. Then, as a very young choreographer, freshly out of school, works with an independent company of young people, again, in a city in Romania, not in Bucharest, and then she comes saying, I don't have a contract, and they don't even put me on the poster. Okay, so how can you prove that you actually worked for that performance? Well, I have some people willing to give some witness testimony. Great, that doesn't work. That's not enough. Why did you go up to the premiere without a contract, without any kind of formal something? At the premiere, you already knew that you are not in the poster. How come did you end up in this situation? Then somebody who's also a critic published a book, a collective book with text written by several people in Romanian and English. And at some point, the English version of a text written by somebody else was published by that somebody else in another book. And the discussion was, but you didn't, without asking the translator. And without asking the publisher of the first edition. The publisher of the first edition said, well, I have the rights, how did you do that? Well, when we looked into the contract, actually the contract that the translator had with the first publisher was a very, very nice service provision contract. There were no copyrights transferred. So the publisher was not there. But in the end, the translator got some money, well, a decent amount from the second publisher because nobody asked him. Taking advantage of the fact that it was a public institution, very reluctant to scandals and so on. So everything, everything looks great on paper. Everybody working in theater has the right to a contract, a copyright contract, a very nicely, very cheaply taxed contract. But people are not, they don't know their basic rights. Everything is very, what the contracts say is very relative. Sometimes we don't know what rights are licensed to whom, for what period, for what territory. And usually nobody asks lawyers or legal consultants because we are all literate intellectual people, so we know how to read the law, we know how to read contracts, so we know. This is the practice. So we can have the conversation about what exactly is protected, but in theater everything can be protected because it's very generous in legally, and the actual everyday situation where the said copyright contract is seen by everybody as a very efficient fiscal mechanism, not a form of protection of rights. And usually people learn about the fact that there are different kinds of rights that can be licensed, about the duration of licensing when it is too late.
This is actually something that we also read in a lot of responses to the questionnaire that we had, because we asked, one part was very practical on how do you work, what is your work environment like, and we also asked, what kind of contracts do you use? Can you negotiate, can you not? Is it just a boilerplate contract that everyone signs off? And there we had kind of what you're describing, that many people came back to us saying, yeah, well, they just sign because they don't know, and then they're also a bit afraid that if they don't sign it, the job will be given to someone else. And you need to use the microphone.
Neither part knows. It's not like
the
contracts are not exactly abusive. They are not applicable sometimes.
This is also what we heard, and then you can give a comment, that the quality of contracts is not great, and then this is also then linked to just people not understanding copyright well enough to know what they're actually asking for or giving up or not.
I just want to ask you a question, because the practice in the theater are very diverse. For instance, I worked 25 years with Peter Brook with a contract of 6 months. And I create a lot of space and I don't have to have a copyright for that, but what kind of protection without contract? Because in one hand, my sketch prove I've done something. But the actor of Peter Brook, they were a real creative person, because Peter Brook worked from improvisation. But the copyright comes from Peter Brook or for the actors? Because they're on a contract. So that's the second point we have to think about. How can we change the practice? How can we tell the artists to protect themselves?
Well, I think I'm able to speak loud because I have a lot of practice in court. So you have not only one question there. There are many. So first of all, the legal landscapes are different, even between so related countries as Romania and France. Our laws are quite similar, but not identical. And as usually, the devil is in the little details. In this moment, I don't remember exact the English translation of the expression a preconstitui o probă. To pre-build.
Pre-establish proof.
A proof. So it's important to any creative person to pre-establish a proof of his/her creation. This is important because this is a matter of fact, and when you go in the court, you can use all way of proofs. You'll be very creative in establishing this proof, actually. Even diaries. Today I propose that, I drawing that, I could be a proof. If you send this, I don't know, a message to other person, this could be a proof. And it's really
Even
important.
the proof of calls that you had lengthy phone conversations with the director, for instance. Everything that can corroborate your.
To write or to be filmed.
No, actually, you have to pay attention to archive your work.
Please make difference between a condition of law. For example, we have not in this law, this condition, the tangibility of the creation. In other laws, other national laws, there is this kind of condition. We have not, thanks to God. But it's a matter of proofing. We have not condition as, condition de fond. But it's a question of
Form.
proofing.
Yeah, because in France, for instance, the law moved from the courtyard. Because for a long time, in a live art, there is no regulation. And the director are artists now for about 10 years, 12 years in France. They were not a creative person before. I'm a scenographer, protect from 3 or 4 years as an author. But I'm still technician. So I'm an author for the social security, but not for...
So, well, in Romania, you have a better condition.
Yeah, exactly. Exactly.
Yeah, actually.
So most of the regulation were moving in France from the court. But the situation of the art in live art move always. So the situation of the artists are not at the same level than the court.
Well, and I want to say something in response of Mr. Popovici. A lot of litigious situation never goes to the court. Why? Because the point of negotiation of the, let's say, producer.
Use it. No, just use
Well, generally, the artists are the weak part of the negotiation. The theater directors, the film producers are the strong part. And in an informal way, they say, if you go to the court, you never shall have a new contract with me. That's the truth. For example, I shall tell you a story from my family. My sister is actress. Many years ago, she was a student in theater university in Bucharest, and she was to a casting for radio advertising. She was a casting of voice exercise there. And but she never had a contract. It was just a casting. Some weeks ago, after that, she said, well, it's my voice on the radio. What? Yeah, it was her voice. Well, it was strange because it was an advertising to a, let's say, big merchant who has as an advertising agency one of my clients. And I take the phone. Man, you are crazy. You see that is the same family name as myself. Well, we don't know nothing. The advertising agency was right. It was the post-production agency who have a little business, and they created a little radio advertising. Well, I sent a notification, come here to discuss. And at the end, they understood that have to pay some money. It was a good amount of money because at that moment, this kind of fact was a criminal offense under Romanian law. And this post-production agency manager told me, okay, I should give you to your sister, actually, to my sister, that money. But I promise you that your sister never shall have a new contract in advertising in Romania. That's true. My sister never shall have a new contract in advertising. The strange story is that this bad guy now is my client, which is strange. But in the same time, my sister never had a new contract in radio advertising in Romania.
There's a very similar case to what you just
Yeah.
mentioned. So with the case with the actress who recorded the voice for the subway. Yes.
Yeah, I know. I know her.
And then the contract expired, but still her voice was on the subway for many, many years.
That's the same with the image of the person. We have now, if you saw,
I know Isabella.
we share the same Facebook. You know, there's now going on a case of lapsed license for an advertisement using the image of an actress that is still on all the big buildings around subway stations. This is the most common copyright infringement in advertisement, using more territories than the license went.
Territory or time-wise, because the one with the
Yes,
subway,
yes.
it was
It's
about
or
the
time
time.
or
I think
territory.
she signed for a year or two, but then her voice on the subway went on for like 10 to 15 years.
I think finally they had a transaction.
Yeah, they had in the
Yeah.
end, but she had to go to court for that.
Yeah.
Can I have a question now? Is that okay?
Yeah.
I have a question going back to something that you mentioned about the moral rights, when you made the distinctions between the material rights and the moral rights, and then you said that the material rights, they expire after 70 years, but then the moral rights, they keep
70
going.
years after the death.
After
of
the death,
author.
of the author. But then the moral rights, they keep going. Who is entitled to claim moral copyrights? Well, if there is no family, or because it was in the context where you spoke about Shakespeare. And I was just wondering, okay, we still have the moral rights, which we know that, their paternity and, naming the author. Who is entitled to claim these moral? Okay, they exist, but who can claim them?
It's not who's entitled to claim, but who can ask for their protection.
Okay, so
No.
what's the answer to that? Okay.
The answer, for instance, the question is now, tell me an author that is dead more than 70 years.
More than
Shakespeare.
Let's say.
No, Romanian.
Nicolae Filimon.
Mihail Sebastian. It's a case that recently we had 7 years since he passed away.
Who?
Sebastian. Mihail Sebastian.
Okay, let's say somebody uses a part of from 2000 years as party material for a fascist party. I think everybody who thinks himself offensed by that, who has, let's say, a very general legitimate right, can protest this. Because I don't, with Sebastian is easy, but it happened in other countries with people, with dead authors that didn't have any relatives alive. And it was, for instance, the Jewish community that protested. Because this is the main thing with moral rights. The thing that somebody nefarious can use the name and the work of somebody against the values of the work and the person. For instance, this is the most ideal situation: a fascist, anti-Semite party and Mihail Sebastian.
Oh.
Do you know cases?
No, but I'm thinking now to your question. I think there are two different legal issues in your question. I think one is from, let's say, copyright matter, and one is from image rights and name rights legal matter, which in Romania is regulated by civil code.
But still part of the copyright, the naming right.
Not only.
No, these
It's-
are personal rights.
Yeah, personal rights.
Naming right is not a
No.
Is not an
No, copyright
Okay.
is looking only to creations, to work. The name, it's an identity element. That's all.
I'm sorry, I'm going to just switch for a second to Romanian just to make sure I understand. I just want to, for 1 second.
So,
Just 1 second, one second. Dreptul la paternitate asupra operei nu se referă la naming rights?
nu. o scriere de Mihail Sebastian este drept la paternitate, dar numele Mihail Sebastian în sine este dreptul lui personal.
Okay. Okay. I was referring to paternity rights, meaning in the sense of the dreptul la paternitatea operei, the drept moral. I'm sorry, switching to Romanian, but I wasn't clear that we speak about the same thing. Yeah.
2,000 years is copyright. If they use the name Mihail Sebastian, is
Okay.
the name.
Now, for instance, Peter Brook did a Beckett play, Happy Day. And when you see the text of Shakespeare or Beckett are different, because in the text of Beckett, there is a didascaly, the little line who say, there is a window. So the editor who protects the right of Beckett came to the theater and say, you cannot have the right.
Well, where's the window?
That's not the money problem, it's a moral questions. You know, so it's interesting with the writer of today. They have a didascaly or not? Because the author can say, I'm sorry, but my idea was not this. Yes, but it's not on your book.
And if this element is essential to the work, you have to respect it.
Yeah. Well,
And then it's the court of law that decides what's essential to the
Or not.
to the work.
Yeah.
and just one more very short question regarding to something that you said at the beginning of the conversation when you spoke about the implementation of the European directive, and that for the first time in 1996, then we developed the related rights, and finally actors were recognized somehow. Now the question is, isn't there maybe a problem of the definition of related rights versus copyrights? Because I'm trying to understand why anywhere in Europe, at least in the European Union, actors' rights are not copyrights, are only related rights everywhere.
Yeah.
There is no place where actors are recognized as creators.
No. It's a question of history.
Because,
Actually, no.
yeah,
Even before law number 8 on 96, we have a good law. The former decree 321 or 1956 was a communist decree, but it was good one. For that time, was a good one. Actually, it was really, really modern at this time. But in 1956, nowhere in Europe was other kind of law. It was really, actually, for that time, Romania, the communist Romania was a very progressive in this respect. I don't know why, but that's true. The question is, it's historical. And well, we have to go back to the statute of Queen Anne and etc. Actually, it was not a right. At the beginning was a privilege. The king said, you have permission to, I don't know, to have a copy, to make copy after this work. It was not a right. And at the beginning was, the privilege goes to the guilds of, I don't know what country or town. And at the beginning, it was the authors of plays, of the novels. At that time, your profession was not viewed as art. It was, you know, as myself, that
It was a métier.
métier, and actually not so good viewed.
what about stage design, stage directors? What about directors?
Sorry, but the stage director appeared at the end of 19th century. By then, we already had some copyrights.
and now they are under the copyrights, or they're
It depends on the country.
in Romania.
In Romania, there are
As I told you, it's a schizophrenic situation.
usually they are the most simple version, and the intention of the law is for them to have related rights. Why? Because in 1990, and that part was not modified. In 1996, the standard was to view the director, the stage director, as somebody who stages pre-existing works. And because this, there is a complication with the playwright, but it depends on the work that the director does on the text.
The reason is
So we go to the judge for him to decide.
No.
actually we come back once again at history. Our law said the performing artists are the person playing, directing, etc., because we copied exactly the article from the French law, and the French law said in this respect. But as I told you at the beginning of my word, in the same time, the dramatic work is a work, and an adaptation or any transformation of this work is work. But the person having the right over a work is an author. So, well, this is the schizophrenic.
Much more organized, and then maybe we can. That's the second part we want to cut. How we can move ahead and transform and take an idea from, for instance, the cinema, which is very well organized. And I suggest to have 5-minute break, and then.
Pamela wanted to say something.
Pamela wanted to say something.
I will say.
Okay. Can I just say you're going round in circles? It's very interesting, but you're going round in circles. I just want to say something. In the UK, everybody has an agent. That agent has to issue you with a contract, and you do not do any work until the contract has been agreed, and that contract includes copyright. Okay, so that's the first thing. Now, you might say to me, how did that all happen? And it happened because many years ago, there was Equity, who is the actors' union, who took care over contracts. But there was 100% nothing for visual artists, directors, or as we called it in the olden days, and please do not call it now, set designers, scenographers, please. And because of that, we formed a society called the Society of British Theatre Designers. And this was extremely positive and extremely active, so that eventually Equity decided that they should have a separate but comparative part of their union as the Society of British Theatre Designers. And because of that, I've never heard such complicated issues going on. I can see why they come, but united we stand and divided we fall. Isn't that the truth? So by being together, we help, we help ourselves. I'm just doing, at this minute, just beginning a project of a well-known film in Tokyo by George Bernard Shaw, great English writer. And my agent has said, do not do a single drawing until you have the contract. Okay, that's how we work.
You have to explain the British system, UK system. Is different from the European one.
I don't think it is.
Yeah, it is.
Well, then the European one should take its heading from the British one, if you don't mind me saying.
How do you manage to pay the agent if you're an emerging?
Well, you have to pay. You pay an agent. I pay my agent every time she negotiates something for me. Okay, I'm going.
So
now.
the question was, how do you manage to pay for the agent, especially if you're an emerging artist, young artist?
Okay, well, I'm very old. I've emerged, you see. So I don't know. But you can't work in Britain unless you have an agent.
So maybe we come back to in 5 minutes, and then we.
I love your position.
But we have to make clear the Anglo-Saxon system, British and American. I don't think Canada have the same system. It's much more close to the European one. But Christina know more about this. No, no. But there is two system. For instance, in America, most of the directors who make a film are also producer. There is a big scandal with Orson Welles. You remember when he makes that film where the end was cut by the producer, and Orson Welles go to Geneva to the court, and he cannot win. The producer have at that time, and it's still the same, all the right. So most of the directors now are also producers, that they can do what they want with. So it's a different system. When you are artist in the UK or in America, the right belong to the producer, not to you, except if you deposit or you pay for to have the copyright. So let's stop 5 minutes and then we start again.
Agent, for sure.
I think it's article number 46 in our law. I'm not sure, but I think it's 46. The assignment contract has to mention expressly the right assigned, the way to use each right assigned, the territory, the duration of the fee. So, well, the data is in your contract, but so if you put in your contract, you shall use my costume only for, I don't know, show entitled, I don't know how, for starting with date of today and ended to the date of tomorrow. Any use over this permission is bad, so you have to go to me, and I go for you in the court, and we shall have money together.
Or you can establish a certain percentage of the, if they, for the outside renting of the costume, 10% of the cost received comes to me. And you give me, you know, the listing of the situation where you rented and the fees that you got for them. Yeah,
Same thing with the set. But it's not just that, because they use your set and they change the color.
Yeah, well, sorry.
They paint in black, for instance. But it's your set. So if you could prove this form is mine and they change the color, you can go to the court. But always we have to go to the court. That's why we have to talk about how artists can be better protected without to have to go to the court. For instance, if the union can defend, you know, because many young set design or costume design, and it's even more complicated for the light design. If you want to say something, Christine, about that, because when start the protection for the light?
Yes, actually in France it's a very special and difficult situation. As I'm vice president of the lighting designer organization, and there is in France a list of artist author. And since 2 years, they get out the lighting designer. We don't know why. There were the sound, the video, the scenographers, but light was put away. And so as an organization, we couldn't change anything. They don't hear us. So now actually we are obliged to get the Union of Scenographers. And now the UDS, Union of Scenographers, now they have 3 branches: scenographer for space, scenographer for costume, and they created for us scenographer for light design. And I hope that after that we will get this list again.
But you're still not an author.
No.
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 Yeah. So that's the real question for, because there is a lot of young creative person in the theater and the dance company and the circus, so street theater, for instance. Street theater, it's a huge develop. There is a festival in Sibiu where half of the festival is on the street. And most of these people, they don't know they are all copy each other. You know, because it's easy to take photo, you know, how they can be protected without to have to pay a lawyer to get back a little money. But how they can protect their moral right. You know, because I see, from my experience, I work in an opera where I did about 14 opera on a long time. So when I visit the storage place, I can see my set. They are reused because they are not the same color. They never call me. They never tell me. So, you know, you can be surprised as a costume designer to see your costume on stage, you know, with a different color. So we have to change the practice. And when you sign your contract, you sign a contract for the creation of the play, but not for after. Do we have to, yeah, should we have in a contract, they have to destroy your work after?
Well,
The contracts come from the theater and very late.
well,
We've
I'm not a
already
wizard and I have not magical solutions, but for sure you need better contracts.
Yeah.
Probably you, person X or person Y, has not enough possibilities to, I don't know, to order to a lawyer to give you a good contract. But maybe you shall be able with your colleagues to create a union, an association, and together to order for a contract.
we are in Neustadt.
And if in this kind of union you shall have around, let's say, 60% of your profession, active member in the market, you shall be able to influence the theater. I think so. It will be not easy. As I told before, I tried twice some years ago to create a union for actors. It was not possible. It was not possible. Yeah. Why? It's a long story, but it was not possible. Probably it will be not easy even in your profession, where maybe, I don't know, but maybe the orgueil are not so big as in actors matter. I don't know.
So let's be clear. In Romania, you cannot form a trade union, a syndicat. Because in Romania, the law limits the possibility of unionizing to employees with labor contracts in a certain enterprise, company, and so on. But as an organization representing the rights and blah, blah, blah of scenographers, you, OISTAT, can employ a legal consultant or contract a lawyer to give legal assistance to the members. The problem also, if OISTAT becomes an association of professional cultural workers, this new fiscal and legal entity that exists now. The difference is OISTAT as it is now doesn't have the advantages of a trade union to actually, for instance, establish minimum fees or standard contract clauses and so on, because that's something that only the trade unions can make as social partners, and this new thing that is the association. Now, we tried this, the Ministry of Labor and the Competition Council saying that if somebody tries to make a minimum fee for somebody that is not a union, this is against European competition. But you can do a lot. First, as Mr. Colan said, you can actually influence things.
Yeah, I agree.
And then you can have, standard clauses that are agreed between you, that are not, issued from this social dialogue that cannot exist officially. And you can have this, standard legal assistance that you all need, and apparently nobody realizes that cannot be gotten without pay, through their own means and so on. That's why lawyers are here. And actually, a situation like this could help in forming legal consultants and lawyers specialized in this field and these issues, because not all lawyers have actresses as sisters. Not all of them have this personal interest in the issue. And sometimes you can fall onto a lawyer that has very original opinions and doesn't actually know. And this way, with everybody like going on all fields, you cannot have a common practice. I saw a lot of contracts of all professions in theater, and apparently there's a certain employee in the legal department at the theater that has a certain opinion of how the contracts should look. And it's like, people employed in theaters at the legal department are not the smartest in the field. Unfortunately, they should be, but the salaries are very low, so it's not the brightest of a generation that go there.
And I had a question about...
To be complete, this is for the money question.
Sorry?
This is for money part. On the other side, you don't need a contract to tell the theater they cannot change your costume. That's the other side. If they reuse you and you have a contract, you can have a money, but the moral right belongs to you forever, contract or no contract. So the theater cannot transform it without to ask you. Then you can go to the court without to ask for money, just to ask for the protection. And there is a lot of sculptors who have a sculpture on the street, and they win each time.
Yeah, sorry. You're right. You don't need to have the contract, but in case of, you need to go to the court.
It's better.
So it's the same.
To have.
And yeah.
That's why we have to change the contract, because there is no line about the moral right in any contract. There is just, we talk about the money, and I have to be careful for when I give my right to do the creation of the opera or the theater, I never see any date. So I give my right forever. Which,
It's not possible to give rights forever.
Yeah, but it's not clear.
Even you shall see in all contracts this phrase.
It's not clear.
No, it says that you cannot give it forever. It says.
No, of course, but if there is no date, they don't call you. Oh, but you give the contract. So you have to, one more time, to go to the court to get a little money. So, But the question is, how can we, probably with WIPO, we will have to have a new questionnaire soon to ask everybody how the contract should be. Because our job, I don't work in France for 20 years now. So our job are all around the world. The contracts are completely different from one country to another country. I come from Mexico, my contract is like this. With Peter Brook is 1 page. So they don't, all that page in Mexico, it's to protect the theater, not me. All the line is for the theater. So it will be, the next step will be this, and we have to talk about that question of also how can we spread the information through union all around the world.
Yes, one thing that I learned from the brainstorming section with WIPO is like when you design something, your idea, you have to make it tangible as an expression. Then you can own your protection. This is the things, like a core thing. And then what I learned from my colleague from Argentina, from Malia, she told me that if you want to own something, you have to do a well archive of your work to back up your thing that, oh, this is belong to you. And then, like, as I mentioned in the beginning of the talk, that Thailand's like IP is widely applied into like the creative industry, which is like in films, in music, which is like generate some income. But in performing art, IP is like rarely apply into like the way we work. We don't have like a formal contact, so we work like in negotiations, like because like in theaters, working in performing art area, we don't have like a funding from the government. We have like a really little, since the performing art sector in Thailand like creates just only like 7% of the GDP, and also like that 7% is from the cultural show. It's not from the contemporary art, like contemporary performing art. So what we have to do right now is like we have to create a platform that advocate for the Thai performing art artists. It's like they get some knowledge about IP, how can they protect their own right, and also it's like stepping on and on, like how can they create the unions and all, just only the group that they can stand for and represent their work. So this is it. And then from your study case that you share, like in the beginning, the earlier, like I feel like Romanians performing art sectors like has been localizing the rule or the laws with the artists already. And it's like, so the thing is like we need to like have coming up with some kinds like people in the middle, like art managers. Like if you don't need to use the lawyer because it costs a lot having a lawyer or having an agency, so working with the art managers or cultural managers, like that gonna be the starting point for the artists to apply, like slightly apply into the IP. And I think they should have, like in the short term, we should have any education program starting from the university, take it serious, educate the student or emerging artists about the IP right. This is the short term for me, and then long term, like collaborating with the government body, working on these issues, like creating unions or any associations, or even the art policy that might be necessary. So this is my idea.
Yes, I had a question to compare our situation in France with other countries. We can divide our job, well, even in scenography, light design or video design for performing arts, we can divide our job in two parts. The creative moment, when we fabric the thing, so it's a kind of salary, and then the rights. And in France, nowadays, the big opera or big theater very often say to the designers, well, do you want copyright or salary? And we are in front of this choice, which is unfair. And I wanted to know if it happens in other countries.
In France, it's for income tax. Because if you are paid that way or that way, you don't pay the same tax to the government. That's why. But that doesn't protect you better. Yeah, it's
quite similar in Romania, but actually, no. It's quite similar in Romania, and probably it's similar in almost EU countries. If I know, even in France, the contracts, at least in movie industry, but I think even in theater is the same.
Is more of the time it's 50-50.
Yeah, they have two parts of the contract. It's one employing for doing something, for going to the theater and working something, and this is put on the taxes as quota de travail, and after that, labor contract, and after that is the part of, say, of the rights, of the copyright. This could be, well, actually, this possibility is open even in Romania, but from the fiscal reason, as Mrs. Popovici said, we shall use copyright contracts. I repeat, I've seen situation in, let's say, an advertising agency where even the car drivers of the agency have copyright contracts. And our IRS, enough in Romania, some years ago said, okay, we are open-minded. What is the work? Well, and a smart guy from the advertising agency says, well, this car driver is an artist of the wheel. Well, unfortunately, our IRS said, it's a smart joke, but you have to give back some money to the state.
Actors in Romania that are employed in public theaters, because we have a lot of public theaters, that's the main network, where the basic form of contracting is labor contracts. So by default and according to the law, these actors and set designer and directors have a part of the contract that is copyright licensing, transfer of rights, but it has to specifically note the rights that are transferred. For instance, this proved to be an issue during the pandemics because it proved that nobody paid attention to this. It was like all the rights on the planet. Nobody said exactly what. And didn't cover basically with this formulation the streaming, the live streaming of performances. Even now, it's not clear in these situations how can the actor, the employed actor, actually negotiate a limit of this transfer of rights, because they don't know and so on. It proved very, very problematic during the pandemics, which was the moment when everybody realized that it doesn't work with all the rights for everything for all the time, or doesn't work like that. But it actually, in Romania, labor contracts offer the highest level of all kinds of protection, social protection, health protection, everything. And when they do have these clauses on transfer of copyrights that are well done, it should be the ideal for, in terms of the quality of life. Because the copyright contracts are very limited in a kind of of actual protections. Effective. Actual and effective. So we would like to, in the ideal, we'd like to have everybody having labor contracts, but at the taxation of 43%, it's unsustainable.
საქართველოში ძირითადად არის ერთიანი კონტრაქტი, რომელიც ძირითადად ეხება შექმნას და ერთ-ერთი ნაწილია კონტრაქტის უფლებები, აი საავტორო უფლებები.
In Georgia, they mainly use a contract which combines the creation of work, plus there is a part about copyright in it.
იმ შემთხვევაში, როდესაც სცენოგრაფებზე ყველაზე მეტი ვიცი, ასე ვთქვათ, თუ სცენოგრაფები არიან დასაქმებულები, როგორც თანამშრომლები თეატრის, იმას ერიცხება ხელფასი, ანუ creation-ზე აღარ აკეთს ცალკე კონტრაქტი, მაგრამ უფლებების ნაწილი არის კონტრაქტში.
If, for example, scenographers have a contract, their employers so have an employer contract, but there is a part about copyright in the contract.
მაგრამ თუ მოწვეული მხატვარია და უმეტეს შემთხვევაში სცენოგრაფები მოწვეული მხატვრები არიან.
But if scenographer is an invited scenographer, in this case,
ამ შემთხვევაში აი ესეთი ვარიანტია creation and copyright ერთად.
Creation and copyright is the very
მაგრამ არის ასევე მომენტი, როდესაც სთავაზობენ უფრო მაღალ ანაზღაურებას ამ საავტორო უფლებების, ასე ვთქვათ, მატერიალური შემდგომი, ასე ვთქვათ, გამოყენების თეატრისთვის უფლების მატერიალური გადაცემის შესახებ. ანუ თუ უფრო დიდი თანხა ჭირდება ერთჯერადად ადამიანს.
And
ის ყიდის ამ
there are
უფლებებს.
times that scenographers are, in these cases, offer the higher payment in order for them to give rights to use the creation afterwards.
მაგრამ თუ აღმოჩნდა, რომ სპექტაკლი პოპულარულია და დიდხანს გადის, ამ შემთხვევაში ხელოვანი წაგებულია, იმიტომ რომ ამ საავტორო პროცენტი გამოდის უფრო დიდი, ვიდრე ის, რაც ერთჯერადად აიღო.
But if at the end it turns out that the play is quite famous and it is played many times for a long time, scenography, of course, in this last case is in a bad situation, basically, because the percentage of that payment, first payment, is low.
მაგრამ ნუ აი როგორც ჟანგი მახსენა, ხშირია, როდესაც კონტრაქტის პირობებით გეკუთვნის საავტორო უფლება, სპექტაკლი აღარ მიდის, მაგრამ ის შენი ნამუშევარი სცენოგრაფიული გამოყენებულია სხვა სპექტაკლებში ან წარმოდგენებში და ამ შემთხვევაში მხატვარს აღარ უხდიან. მე თვითონ მქონდა ასეთი მწარე გამოცდილება.
There are cases, for example, when a scenographer is ანუ აღარ უხდიან იმ შემთხვევაში თუ
სპექტაკლი აღარ მიდის, მაგრამ დეკორაციის ნაწილს
if a play is not used anymore, for example, and in this case, but the contract was made about the creation and the copyright. But if the play is not used anymore, the artist, scenographer is not paid for the copyright afterwards. Yeah.
It's good now.
Yeah.
Yeah, like that.
Yeah. It's okay.
და
Okay. So,
okay.
yeah, that's.
არა, ამ წუთას არა, მაგრამ
No.
So, there is a paradox. If you are working in a new opera with somebody who have made the text of the opera and the composer, every day they get a royalty because they are very well protected, the composer and the writer, because there is a part on the ticket who go to them. But not the director, not the set design, not the costume design, not the light design, not the props design, you know.
You can negotiate in this respect.
Yeah, exactly. And there is a theater in France where they create a UNESCO, the chair, for the first time in Paris, in very little theater. And there is 4 actors, and one of the actors want to have a contract where he have a salary for all his work. And the other one, they have 50% in participation. And now for 50 years. So
good deal.
So it's something we have to think about for the author to be also to take a risk in a creation. What do you think?
Well, it's nice as idea, for sure. I like it. But it's difficult for me to believe that, let's say, public substandard theaters in Romania shall accept this proposal. In realistic terms, well, it's just a dream. I think so. It's my opinion. It's just an opinion. I like it, but I really don't believe that the state theater, let's say, shall accept it.
That will protect better the creative person or not?
No, I don't think so. Maybe I repeat, maybe private projects shall accept it. It will be easier to accept. But for public sustained theaters, I don't think so.
უთხარი რომ საქართველოში არის საქართველოში უმეტესი თეატრები არის სახელმწიფო და ამ სახელმწიფო თეატრებში ფაქტობრივად აი ეს ბიუჯეტიდან გაყიდული ფონდის შეძლება საერთოდ ჯგუფს. პროცენტული განგარიშების დოკუმენტები.
In Georgia, most of the theaters are public, and percentage from the sales of the tickets are given to the whole collective. And there's a document that is proving that. და ესა გამეორებაო კონტრაქტის შესაბამისად გამეორების შემთხვევაშიო, ანუ სპექტაკლების გამეორების შემთხვევაში კონტრაქტით ხდებაო?
ამას ვამბობდი, რომ სწორედ თუ შენ მოაწერე ხელი იმას, რომ საავტორო უფლებები გეკუთვნის ფინანსურად, რამდენი ხანიც არ უნდა წავიდეს ეს სპექტაკლი, სადადგმო ჯგუფს, რეჟისორს, სცენოგრაფს, კოსტუმების მხატვარს, ქორეოგრაფს, დრამატურგს ამ გაყიდული ბილეთის პროცენტი გადაეცემა. და რეჟისორს მაღალი პროცენტია.
If you have once signed the contract, which includes the copyright, if the repetition of the play goes on, the whole collective of the play receives you call it royalty, right? Royalties, which is like a percentage from the sales of the tickets. The director has the highest percentage, for example. The dramaturg has the highest, and then the director percentage. The organization which is active in Georgia about the property rights is the creator of this document, and it was created in 2014. Yeah. And if you have an interest, we can send you this document, of course. 2014. Did I say the 19? 2014.
So what is the criteria that apply to generate the percentage of each position in yes.
The criteria was decided by the organization which implements the property rights, which protects the property rights. But it is not written in the law. And because it is not in the law, judge might not decide to not to consider the case.
So that's the common agreement between. Is that going to be a common agreement between each positions before working like, or that just have like already have a template of that?
ანუ ეს მიღებული ფორმა არისო, თქვათ, წყდება შიგნითო, თქვათ, აი ამ საავტორო უფლებების ერთული მართვის ორგანიზაცია მოადგილეს ამ კოლექტივებთან ერთად და ახლა საყოველთაოდ საქართველოში ამ ტარიფებს ხმარობენ. It was created by the organization in agreement with the collectives, and nowadays this is very active in Georgia.
Yeah, because about the copyright, there is also two possibilities to sign the contract where all the rights belong to the director. All the rights go to the director, and then he pay everybody and nobody have any right, or exactly the opposite. Yeah. And on the other side, it's a traditional contract where there is a repartition of a percentage for each one to have a royalty on the copyright. Yeah. So that's why, yeah. This is why maybe
we have only for everyone.
Yeah.
Yeah.
Because we can have a model of a cinema where they are very well organized, where the copyright have it's in a contract of everyone. Everyone have a percentage on the copyright.
In cinema.
Yeah, in a cinema, yes.
In Georgia, in theater, everyone has.
In the theater?
In the theater,
Yeah.
yes. If there is a case when a producer, there's a private producer, then the producer has all the rights. But this is very rare, and it happens mostly in the cinema field. And that one is in the law, mentioned in the law.
The producer.
The producer.
Yeah, that's American system where all the rights belong to the producer.
American system, so I get here. Producers role. Oh, but in our law, producers in theater don't exist. Mainly don't exist. Yeah.
So we have to finish. It's something like 6 o'clock. Do you have any question? What? Do you want to add something?
I spoke a lot.
No, but if you have to add 2 minutes, no. Okay. Thank you very much to everyone. Thank you to you.
Yes, thank you very
And
much.
Question. Is it possible to have to consult an abstract of your questionnaire?
We don't have like a condensed document summarizing it, in fact.
Yeah, that's we need absolutely to spread that question and to organize something like this, maybe in Asia once, because slowly the information is going through the union and through the people everywhere, and then we have to go ahead about this question of contract and also to spread the information to everybody, to tell everybody how to protect, and they don't know that. Thank you.